This conditional use hearing to order.
Thank you. This is a hearing on a conditional use application of Steepleview LP seeking conditional use approval for 6 multifamily residential structures with condominiums, 5 mixed-use residential and retail structures, and a parking structure in a traditional neighborhood development, TND1, for the properties known as 200 through 212 South State Street, Newtown Borough, Bucks County, Pennsylvania. The property is located in the V2 Village Gateway Zoning District and designated as Bucks County tax map parcel numbers 2801-007, 2801-008, 2801-009, and 2801-010. Just for the information of the public that are appearing for this hearing or present here today, the council is sitting as a quasi-judicial board. Council will receive evidence and will make a determination in accordance with applicable law. During the course of this hearing, the strict rules of evidence are not applicable, but council may reject evidence that it deems to be irrelevant, immaterial, or repetitious. Council may convene to executive session to discuss the application or to deliberate this matter. As this is a conditional use application, at the end, once all the evidence is presented, council may choose to deny the application, grant the application, or grant the application and impose reasonable conditions. This is a public hearing. The hearing is being held and convened within 60 days of the submission of the application, which took place on October 10, 2011, and a record of this proceeding is being taken by a stenographer. The parties to this hearing under the ordinances automatically include the applicant and the borough. In addition, any party, including a civic or community organization affected by the application, may seek party status. Party status would give that person the ability to question witnesses and present their own evidence. Party status is not necessary if you wish to be heard. After all of the parties have presented their evidence in this proceeding, anybody who wishes to make public comment on this application will have an opportunity to do so. So at this time, what I'd like to do is ask if there is anybody present in the audience who wishes to take party status to this application in this hearing.
Yes, my name is Alan Toadvine.
Sorry, sir. Again?
Alan Toadvine, T-O-A-D-V-I-N. And I'm here on behalf of Temp Associates LLC, that's the owner of 5-11 South State Street.
Temp Associates, you said?
LLC.
Now, before I ask if the applicant has any objection, what I think I'd like to do is have all the people who are interested in party status to appear, and that way, if any of the proposed parties have any objection to any of the other parties, we can handle that all at once. So if I could just get the identification of any others interested in taking party status.
Good evening, council members. Hopefully you can hear me. My name is John Koopman. I'm an attorney with the firm of Begley, Carlin, and Mandio. I'm here on behalf of Newtown Township. Newtown Township would like to have party status in this proceeding. As I'm sure you can appreciate, Newtown Township, this property that's the subject of the conditional use application immediately borders Newtown Township, and Newtown Township has certain questions and concerns regarding the proposed development and would like party status on behalf of itself.
Thank you. Is there anyone else wishing to seek party status? Okay. Does the applicant have any objection to either of the parties seeking status?
Mr. Cohen, yes, we do. We object to the applications of both applicants for party status. Under the law, the interest of a third party in order to obtain standing is based upon they have to show a substantial and immediate interest in the proceedings. A substantial interest has a discernible adverse effect upon the party other than an abstract interest that all other citizens have. I understand what the township's position is. I'm not sure who Mr. Toadvine's client is and what kind of adverse impact or interest they would have. As far as the need for an immediate interest, that has to be something more than just remote. There has to be proximity between the property of the person seeking to gain party status and the project site, so that there is some kind of nexus between the proposal and the property owned by the applicant. And I would just ask if both of these parties could perhaps provide additional information on those issues so Borough Council can decide whether or not they meet that standard.
I think it would be appropriate and helpful to council to understand. So Mr. Toadvine, maybe you can offer.
I reviewed the plan, which is...
If you could speak into the microphone, sorry.
Sure.
Thank you.
I reviewed the plan, which was filed in connection with the application, and although there is not a lot of information, what I can tell from the plan is that this development will generate somewhere between 800 and 1,200 trips per day on the South State Street. My client's business is probably 1,000 feet, 900 feet from the only two-way entrance and exit into this proposed development. We believe that that traffic that will be put out onto South State Street will have an adverse impact on my client's business, and that is the basis of our request for party status.
If there's anything you want to add, Mr. Koopman?
Well, yeah, on behalf of Newtown Township, I would like to add a number of things. Newtown Township has an interest which is not just a general interest. Newtown Township directly borders the rear of the subject property. Newtown's interest is several. There's an interest in terms of traffic, because much of the traffic from this development will impact intersections in Newtown Township, including the intersection of Center Avenue or Center Road. And maybe you can correct me, is that referred to as Center Avenue or Center Road? Avenue? Avenue. And Sycamore, and the intersections of Richboro, Newtown Road and the bypass, and South State Street and the bypass. And the township also has other interests in open space, air, interest in riparian rights in the creek, in runoff and impervious surfaces, since this property immediately adjoins the township, and the creek is the boundary line between the township and the borough. We have concerns about the open space, the density certainly, parking requirements, and also yard requirements. I would also point or direct the solicitor's attention to the case of Miller versus Upper Allen Township Zoning Hearing Board, which you may be familiar with, Mr. Cohen. That's a Commonwealth Court case. I can give you a copy. It's a Commonwealth Court case 1987, where the Commonwealth Court essentially held that an adjoining municipality, as well as residents of an adjoining municipality who directly abut the subject property, do have an immediate interest in the proceedings. And in that case, and this is still good law, the Commonwealth Court held that an adjacent municipality that directly adjoined the subject property did have standing to proceed, and that was a special exception case. This is a conditional use case, so I think that is precedent for standing for Newtown Township in this case. I can hand out a little Mr. a copy of that case.
Mr. Duffy, do you have a response?
Yeah, the only response is in connection with Mr. Toadvine's client. That property is, the Temperance House is 2 blocks away from our property. It's not even within the sphere of properties that the borough ordinance is required that we give notice to. Any kind of interest that they would have, any kind of impact about traffic, would be merely a general and remote interest, just like anybody else in town, anyone else around, and therefore it doesn't meet the standard of either a substantial or immediate interest.
Okay. Just to keep the record clear, Mr. Koopman and Mr. Toadvine, do either of your clients object to the entry of party status for the other?
No.
Okay. All right. In light of the limited number of parties that are seeking status, what I would ask is just have a formal motion by council with regard to each objection. That way we can set the record straight as to whether council believes that that the parties seeking status have met the standard, which essentially requires that they show that they would be affected by the property or by the development that's been proposed. Council can adjourn to an executive session if you do want to deliberate, or otherwise, if you're prepared to make a motion, I would request that you do so with respect to each objection.
So we need individual motions, is that what you're suggesting?
If you think that one will do, then
Motion? Separate? Okay, let's make separate motions then. Okay. Someone wish to make a motion?
I would ask for someone to, well, I'll have you make the motion, because I'm not sure where you want to go.
I'll move the council overrule the applicant's objection to the party standing application of Newtown Township.
I'm sorry, sir, I can't hear you.
I'll move the council overrule the applicant's objection to the request for party standing of Newtown Township.
Second.
It's been moved and seconded. Any discussion? Not. All those in favor?
Aye. Aye.
Opposed? Motion carries.
So the township will be granted party status. Make a motion with respect to Temp Associates LLC.
So moved.
To overrule.
To overrule, yes.
Is there a second? Okay.
Sure.
Dying for lack of a second?
Is there another motion that anyone wishes to make?
Okay.
Yes, there's no action on the objection. Party status will be granted at this time.
Pardon? Pardon?
Absent any, I would think the Borough Council would have to make a motion to agree to allow this.
Well, the objection's been
exemption of the
made.
party.
The applicant is looking for action on their objection. The council does need to rule one way or the other, so.
Okay.
You can convene to executive session if you wish to discuss.
Well, I'll try and cut the Gordian knot here. I forget, Mr. Trevon, what's the name of the
Temp Associates LLC.
Temp Associates LLC? I'll move to deny party status for Temp Associates LLC.
And that would be to sustain the applicant's objection.
Correct.
Is there-
Is there a second? Okay.
Do we need to discuss it?
Should we, all right, so we convene, okay.
All right, we're going to convene into executive session. Council has gone through an executive session to discuss the objection that was stated by applicant. Madam President?
Okay, may I have a motion regarding the request for party status by Temp Associates LLC?
I'll make a motion once again to grant them party status.
Second.
And that is a motion to overrule the objection.
Overrule the objection, yes.
Okay, it's been moved and seconded. Any discussion? If not, all those in favor?
Aye.
Opposed? Motion
Opposed.
carries with one opposition.
The objection is overruled and Temp Associates is granted party status.
Thank you.
Before handing it over to the applicant, there are a few exhibits that the borough will be putting on the record as borough exhibits. Going to mark as Borough Exhibit 1, an October 10, 2011 letter from Timothy Duffy accompanying the submission of a conditional use application. Borough Exhibit Number 2 is a conditional use hearing application, Plan A, dated October 7, 2011. Borough Exhibit 3 is a preliminary site plan A prepared by Gilmore and Associates, Inc., dated October 6, 2011, submitted with the application. Borough Exhibit 4, an existing features plan dated October 6, 2011, also submitted with the application. Mr. Duffy, do you confirm that what I've just described is the complete application as submitted?
Yes, I do.
Thank you. Borough 5 is a proof of publication of of an advertisement of a notice of this hearing, which was advertised in the Advance of Bucks County on November 17 and November 24, 2011. And Borough 6 is a letter dated November 17, 2011, from myself to Mr. Duffy, a copy to Joanne Brown, enclosing notice of the conditional use hearing with proof of mailing. Those are the exhibits of the borough, and just a brief announcement before we do get started. Council discussed the hearing for today. What we're going to do is we're going to keep the record open until approximately 9 p.m. this evening. It seems quite likely that we're going to be carrying over until another hearing date. Obviously, if we hit a logical breaking point before then, we might decide to break at that point in time, or if it looks like we're getting somewhere at that time, we might extend it a little bit longer, but just so everybody has an idea, we're looking at about an hour from now. So with that, Mr. Duffy?